So welcome everyone to this webinar. I'm Rafael Carmona from the ICDR. Before we commence, I want to, as usual, take just one moment of your time to remind you that you can join our Young Practitioners Group, ICDR Young and International, as a Y&I associate. In order to do so, you can visit our website. If you Google ICDR Y&I, you will find it. And in our website, you'll find registration forms in English and in Spanish, as well as the recordings of all of our previous webinars, including previous installments of our construction webinar series. So I encourage you to go there and visit our library of webinar programs. We also have a LinkedIn group. Again, it's called ICDR Young and International. So if you look us in LinkedIn, you'll be able to request to join and we'll accept you. We'll also be posting all of our updates there. I also want to very briefly thank our co-sponsors for the series, the ABA Forum on Construction Law, the Society of Construction Law North America, and Y Construction, Young Construction Practitioners. With that, I will give the floor to Katie Gonzalez, our moderator for today, and also a member of our Y&I board. So thank you very much, Katie. And with that, the floor is yours, Katie. Thank you.
Thank you, Rafa, and thank you to all of the participants for being here today to listen to what is assuredly going to be a very interesting discussion. As Rafa mentioned, my name is Katie Gonzalez, and I'm a senior associate in the International Litigation and Arbitration Practice Group at Cleary Gottlieb Steen & Hamilton in New York. And we're really delighted and excited to be here with you today with the support of ICDR and the other sponsors that Rafa just mentioned to bring you what is the second installment in this International Construction Arbitration webinar series on core concepts in arbitration practice. And today we're going to be focusing on the topic of the taking of evidence in international arbitration, where our speakers here today are going to be providing some practical tips and techniques for the taking, preserving, and presenting of evidence so that everyone on this webinar will obtain some of those tactics to be able to be employed in their construction cases. So without further delay, allow me to introduce our esteemed panel of speakers, and we'll dive right into this very interesting topic. First, we have with us today Camila Biral. Camila is a partner at the Arbitration Practice Group at Demarest Advogados, practicing in Sao Paulo, Brazil. Camila has been recognized by various international legal rankings for her performance assisting clients in various industries, including the agribusiness, infrastructure, energy, and technology sectors, as well as more generally in complex arbitration proceedings involving contractual, corporate, and international disputes. Next, we have Simon Brathwaite, who's a chartered quantity surveyor with over 25 years of professional experience in construction and consulting. And Simon is often appointed as an expert witness and has presented written and oral testimony and evidence in domestic and international dispute forums on quantum damages and also delay matters. Simon attained his MSc in construction law and dispute resolution, a postgraduate diploma in quantity surveying, and a BSc with honors in construction management. Simon holds a fellowship of the Royal Institution of Chartered Surveyors, the Chartered Institute of Building, and the Chartered Institution of Civil Engineering Surveyors, and also holds professional membership of the Chartered Institute of Arbitrators and the Academy of Experts. Next, we have Laura Cózar. Laura is a partner of Accuracy and co-leader of its global infrastructure and energy practice. She holds a MSc in civil engineering, an MBA, and studied corporate finance at Wharton and INSEAD. She has advised corporations, investors, lenders, governments, and multilateral agencies in all stages of the life cycle of large projects worldwide, developed under the P3 public-private partnership schemes. And Laura has worked as an independent expert in the quantification of financial damages in over 30 investor, state, and commercial arbitration cases, usually in the context of disputes arising from contractual breaches, shareholder disputes, regulation changes, and construction overruns, among other causes. And finally, we have Aisha Nadar. Aisha is active in international construction and dispute resolution. For 35 years, Aisha has handled all phases of project implementation, and she regularly advises clients on strategic procurement planning, contract drafting, contract management, and dispute resolution. She acts as an arbitrator, mediator, and dispute board member. She is listed on the panel of conciliators at ICSID and is vice chair of the ICC Commission on Arbitration and ADR. She also served as the member of the FIDIC board responsible for the Contracts Committee from 2016 to 2020, and has carried out dispute resolution assignments for organizations such as the World Bank, USAID, and the U.S. Department of Defense. She holds a BS in electrical engineering, an MBA, and an LLM in international commercial dispute resolution. And so before kicking us off on our topic, and with that introduction of our esteemed panelists in mind, I will encourage all of you as we start asking and posing questions to our panelists to also interject if you have any specific questions or burning issues that you would like our panelists to raise. You can, of course, include those questions through the Q&A or the chat function, or simply raise a hand, and we will make sure to call on you so that you can engage in this debate with this great group of people who are going to be speaking on some of these issues. And to perhaps kick us off on our topic, I'll just note that I think the gathering and the taking of evidence can be extremely important in disputes generally, but specifically in this realm of construction disputes that we're focused on today. Because in these types of construction disputes, at least I found in my experience, oftentimes the facts can be just as contested, or perhaps even more so, than some of the legal questions that the tribunal is set out to adjudicate. So developing the evidence in these cases, the evidence that's going to support a party's claims or defenses, can be really, really crucial to the outcome of the case. And oftentimes when we're talking about the collecting and the presenting of evidence, it doesn't just happen during the disclosure period in an arbitration once a dispute has been initiated, but it's a process that actually starts oftentimes much earlier, before an arbitration is even commenced, so that parties can really put their best foot forward in the case. With that sort of brief background in mind, perhaps, Laura, you can provide sort of an in-depth primer for us in terms of what we're actually speaking of when we talk about evidence in these types of construction disputes in international arbitration. So what is the evidence that we're referring to, and how can parties go about developing this evidence early on in a case, even before an arbitration is initiated?
Thank you very much, Katie. Thank you very much, Rafa, and all the attendees. Before digging into the issue, I would like to acknowledge that there is a tension between managing a construction project with a focus on successfully delivering it versus managing a project in a way that prepares you for a potential dispute. Because developing and gathering evidence is time-consuming, and more often than not, the exercise does not really help contractors or owners to improve the processes or to make better decisions in the future, either within the same project or in other projects. And on the other hand, when the project teams puts all the energy and all the effort into delivering the project, there may be some laxity and lack of traceability of certain decisions in the way of informal agreements with the counterparty, of subcontractors, some technical decisions made on the fly without cost-benefit analysis. These issues aggravated by staff rotation, particularly in large international projects, make the lawyers and the experts' work quite difficult when the dispute escalates to an arbitration or a litigation. There is, however, a point in time where I believe both objectives converge, and I refer to tender stage. This is the moment where the contractor establishes its plan to deliver the project on time at a certain price, including a risk management strategy, including their expectation of profitability and overhead recovery. And why did I say that both objectives converge? Both successful project delivery and being well prepared for a dispute. Because irrespective of whether there is a dispute or not in the end, lessons can be learned retrospectively about the pricing strategy, the adequacy of certain contractual terms and risk transfer to subcontractors, about the achievability or not of the productivity rates envisaged at the beginning, and along, etc. But if there is a dispute and the delivery plan with all the technical and commercial inputs are at hand and detailed enough, this piece of evidence is golden. And I'm going to give you a couple of examples where this is really useful. A disruption claim. If the contractor can prove what were the basis for the expected productivity when they were preparing their pricing strategy and their plan to deliver the project, they can also prove that this is being achieved in similar circumstances and that this benchmark was helpful to really develop the strategy and set up the expected productivity rates. And that productivities have been achieved in other similar projects but for the breach situations. It is far easier to build up a disruption claim, starting with a solid narrative, which is something that I usually find missing. When I work in a disruption claim, I normally see the opposing expert or the client talking about formulas and methodologies, and not so much how the project has in fact been affected, or what's the construction process that was disrupted, or what changed in their original plan to deliver the project. So this narrative, accompanied by calculation and the application of the usual methodologies, can make some disruption claims successful, or at least doable and ready to be presented. The other instance in which I was thinking when I was thinking about the tender stage documentation is in the context of disputes raised by contractors, which the owner rejects on the basis that there is a cause-effect link between a too risky price and the circumstances that gave rise to the claim. An example, I was an expert in a project in which because of alleged breaches by the owner, the banks put the financing agreements on hold. So, and as a consequence, the contractor requested a suspension. And later on, as a consequence of the suspension, they raised a prolongation cost claim. The counterparty reacted by saying that it was the contractor's responsibility to be able to fund the project, to finance the project, and that the only reason why they could not finance the project was because of the too risky tender price, which gave no comfort or gave no comfort to the banks. And so it was a sort of self-inflicted damage caused by the suspension. And there are a number of instances where this tender stage documentation, I miss them, and I think it would have been extremely helpful. I could go on and on evidence gathering, but I thought it was different perspective to put together both the commercial interest of the project together with the evidence in an arbitration.
Absolutely. And I think that is such a helpful sort of reminder for us, Laura, that oftentimes when we are talking about the collecting of evidence, it goes to the core of what is the dispute about and how is it going to support the narrative, as you mentioned. And to that end, it can be helpful, as you discussed, to think about the parties' objectives and their expectations entering into the project and throughout the pendency of the project, because usually, of course, the disputes arise when there has been sort of an upset to those expectations or intentions or objectives. And hearing from you about sort of the tender stage documentation that can provide very helpful evidence, I think is sort of a key thing that hopefully our participants will take away as something that as counsel we can be on the lookout for to kind of cultivate to strengthen our cases. Perhaps with that primer, I'll just ask Aisha and Simon if you have anything you'd like to add from your own experiences in terms of identifying evidence and taking and gathering evidence in early stages of these construction disputes, and whether you have any sort of techniques that you've used in your cases to identify and collect that type of evidence.
If I may, just jumping in ahead of Simon, I think adding to Laura, I think the procurement stage is very important, but the project execution stage or the contract execution stage is equally, and I dare say vitally important in preparation for arbitration. While you do, as Laura mentioned, have to focus on project success, but you also have to make sure that your documentation is in order to administer the contract properly or to prepare for potential arbitrations if things do escalate. And I think we need to kind of step back and look at the nature of construction contracts at their core. It is about a dynamic approach to risk allocation. So most construction contracts anticipate that if risks do eventuate, for example, unforeseen site conditions are encountered, that there is, in certain of the contracts, there is a potential for adjustment of the schedule and or cost of the price or the cost of the contract. And that adjustment requires notification, and it requires demonstration of the magnitude of the cost adjustment and the schedule adjustment. So it requires that documentation and the recording of evidence take place even during contract administration. So it's really important for both parties in a construction contract to make sure that they have the right personnel on site that understand how it is they should maintain records and what records are required to demonstrate and prove the entitlement to a cost adjustment or a time adjustment. And it's important that if there is a consent or an acceptance or a disagreement, that these are documented at every step of the contract administration, that correspondence is recorded and filed and protected for easy access. If decisions are made by telephone, you need to inform the personnel that these decisions, verbal agreements need to be reduced to writing in case, because it's in arbitration, it's documents that speak. Oftentimes the project participants have gone on in their careers, and so it is the documents that will speak volumes to prove the facts. And so in addition to keeping those meticulous records, contemporaneous meticulous records, if there is an issue, it is important to line up experts at the moment that we'll talk about site visits later, but it's important to think of site visits at the moment that the issue arises. If something is encountered, if there's a defect, you need to get the experts on hand at the moment that the issue does arise. So it is hope for the best in project success, but prepare for the worst because of this dynamic risk allocation approach. So I'll stop there, and maybe Simon has something to add.
Yeah, just a couple of points, Laura and Aisha, following on from your very important comments there. What this all leads to when you're in the position at this stage where you're about to enter into an arbitration, you've already, you're in a dispute situation. and the preservation of documents is critical importance at that stage. So some of the things that I would look for when preparing claims and expert evidence in relation to delay, and the early things I would look for, is the preservation of the native documents. For example, in relation today, the preservation of native files, XCR files for Primavera schedules, cost reports, etc. All the things that Laura mentioned earlier, the documents that precede that are the documents that you would use on a project to measure your performance in relation to productivity, etc., like Laura mentioned. So the cost records, payment applications, and then depending on the procurement route, if, for example, it's a cost plus project, you'll be measuring the cost expenditure over payment applications, etc., along with the progress in the schedule. So the preservation of native documentation is critical importance when you're in the unfortunate stage of a dispute in arbitration.
Great. Thank you both, and thank you to Laura for kicking us off on that discussion, which I think kind of provides a perfect segue into our next topic. We've been focusing a little bit on the importance of preserving evidence at the outset, perhaps maybe even before a dispute has formally percolated, in order to best position parties to make their arguments and to prove their claims and defenses when we do have an arbitration proceeding. And as I'm sure many of the practitioners on this webinar will appreciate, oftentimes counsel can view it as one of their responsibilities to identify for their clients when there arises a need, whether it's under the local laws or practice or otherwise, to begin preserving those documents. And oftentimes as lawyers, we might issue a document preservation notice to inform the client that they need to be holding communications and turning off any auto delete functions. But I think, as Aisha and Simon aptly pointed out, oftentimes that work must be done even earlier before and involves the business people oftentimes having good record keeping in place. And in-house counsel, I think in particular, can aid in that endeavor by making sure there's active check-ins and monitoring of various projects. Because so frequently as counsel, we find by the time a dispute has occurred and we are in an arbitration proceeding, there might have been, even voluminous letters that have gone back and forth between the parties, which will of course provide core evidence in the dispute. And so it's always very helpful to involve counsel at the drafting stages. Pivoting away from the documentary evidence that we've been discussing, which oftentimes in an arbitration proceeding is adduced during the disclosure process, usually pursuant to a tool or a mechanism like the Redfern schedule, I want to focus a little bit on witness evidence and witness testimony. And perhaps, Camila, we can turn things over to you to provide an introduction based on your experience as to how do we identify and elicit witness testimony in order to best provide evidence of a party's claims or defenses. And in your practice, have you encountered any specific difficulties or challenges in doing so in the context of construction-related disputes?
Katie, thank you very much. And this is the biggest challenge from a lawyer's perspective, I can say, because you can control the document you provide, you can control almost everything in arbitration, but not your witness. So this could be a very surprise thing during the hearing. So this is why it is extremely important to select your witness properly. We typically follow the following approach. First, we identify key individuals. We start by identifying individuals who have direct knowledge of the relevant facts and events. This involves reviewing documents, emails, other records to determine who was really involved in the key aspects of the case. And because the tribunal doesn't want to hear someone that heard to say that, you need to bring someone who knows, who really participated in the project, the eyewitness. So this is the first step. The second approach is assess the credibility and the reliability of this witness. This includes considering their role in the events, their ability to recall the details, and any potential bias or conflict of interest. Here, we should have a careful attention, for example, to witness body language. For example, witness that avoids eye contact and contradict the testimony, because this can reveal insights about their credibility, and this could harm your position in the arbitration. And the third approach is conduct previous interviews. So we conduct preliminary interviews with potential witness to understand their perspective and gather detailed information about their knowledge about the case. This helps us normally to assess the strength of the testimony and identify any gaps or inconsistencies. The fourth step is prepare the witness. We work closely with the selected witness to prepare them for providing testimony. This includes helping them to understand the legal process and also all the hearing steps, the mechanism during the hearing, reviewing relevant documents, and also conducting mock examinations with them to build their confidence and to ensure that they can effectively communicate their knowledge during the hearing to the tribunal. And finally, bringing them calm. This is very important because the witness sometimes they are so in a very uncomfortable zone when they are there in the hearing. So talking about the difficulties and how to overcome them, as you may know, developing facts, witness testimony can present several challenges, Katie. First, memory and recall the issues. We are here talking about a construction, and sometimes witness may have difficulties recalling specific details about the project, about something that occurred in the site. So especially when events occurred a long time ago. So to overcome this, we normally use documents and other records to refresh their memories and provide context. The second challenge that normally we lawyers face is the reluctance to testify. Some witness may be reluctant to testify due to fear or fear of retaliation or other concerns. So we address this by explaining the importance of their testimony, providing reassurance, and if necessary, seeking protective measures to ensure their safety and confidentiality also. The third challenge is the inconsistencies and contradictions. Witness may provide inconsistent or contradiction statements during the hearing. And we address this by carefully reviewing their testimony, identifying previously any discrepancy, and working with them to clarify and reconcile their statements. The fourth challenge is the communication skills. Not all witnesses are skilled at communicating their knowledge effectively. We as counsel, we provide coaching and support to help them to articulate their testimony clearly and confidentially. And one good tip, Katie, very often the charming CEO of the company who speaks very fluently is not your best option as a fact witness, because very experienced arbitrators call them professional witness, which means that whatever you want them to say, they will say. They are always a very good student during the preparation for a hearing. And so the tribunal knows that you can tell and they will learn how to say something. So sometimes an employee who was there at the time of an accident at the site, for example, who represent the workforce is the best option in terms of credibility, because they are not easy to be trained, they are usually more direct, and the tribunal will rely on their testimony. So Katie, those are the main steps that we usually may take to overcome the biggest challenge in terms of this kind of evidence.
That's great. Thank you, Camila. And I think the last point that you flagged is so important because oftentimes, perhaps less expert counsel in these types of, construction and large infrastructure project disputes do sort of have this tendency to want to introduce, one general fact witness who can sort of speak to the entire universe of what was occurring at any given point in time, because perhaps that seems simpler to only deal with one person, to only have to prepare one person to represent a unitary voice to the tribunal. But I think that in the construction arbitration context, oftentimes is not quite as realistic or as compelling to a tribunal, where you might have various engineers or operators or different people that contributed to different aspects of a project that are really going to be the only ones that can credibly speak to that element of the dispute. So at least oftentimes, I think in our practice, we see a number of different fact witnesses being presented, which can appear to be a challenge for counsel, but I think presents more of an opportunity to more holistically present a party's case. Aisha, did you have anything you wanted to add in terms of sort of cultivating this witness testimony?
I did, and I think it's important just to add to Camila's really good and insightful presentation. It is possibly just to remember these engineers or operators are focused on their own career, and their career is not going to be furthered by doing well as a witness. Their career is going to be focused and promoted by working on a successful project. So it may be good to speak to that charming CEO and kind of align the progress of the engineer, the witness engineer's professional progress, and tying it to their successful testimony. So it's kind of wrapping the business, human aspects and promotion, and realizing that it's better to be associated with a successful project as an engineer than it is to be really clever as a witness in an arbitration, because that doesn't help your personal career. So I think that, with counsel working with the CEO or the party, to acknowledge that can be quite useful, because I've been in situations where the best witnesses really want to not have anything to do with this arbitration in any way, shape, or form. So just a practical tip.
If I may add a couple of comments. Camila, you said at the beginning of your presentation how the identification of the witnesses happen. And I would like to bring the expert view on the coordination with you, the lawyers, because there are instances in which there are some gaps of evidence, and that it's very helpful that you provide us with testimony from key witnesses that allow us to fill in the gaps of the evidence, and that's really key. And the other is a comment on the human nature that may be an obstacle, and that we experts are faced with it almost all the time, which is what I call the baby effect, that affects to all engineers, particularly expats in large international projects. They devote their time, effort, and life to a project, and when it comes the moment to look back and explain what happened, trying to rebuild and the decision making and all that, it's usually slightly biased, or let's say when they are confronted normally by us, by experts, we are confronted by evidence, it's really hard to get the real narrative of what happened and why it happened. And they don't mean to lie. It's just a mix of bad memory and some emotions getting in the way.
Just to add to that, Laura, as well, the best witnesses for Laura and I are the fact witnesses on the ground, feet on the ground on the project, not the CEO who has a bottom line to achieve. The best evidence is definitely from the engineers, the project managers, the commercial people on the project. And I think Laura, you kind of kind of mentioned it. There's kind of a little bit of a bridge to close there, because often when you start working on a project, the fact witnesses that you're going to be relying on may initially see it as a little bit of a contentious situation, because the reality is you're sort of scrutinizing the work that they've been doing. And I think it's important when you're communicating with fact witnesses to embellish the fact that you're there to help them, not necessarily scrutinize the work that they've been doing and their performance on the project.
Absolutely. Thank you all so much for those insights. I feel like, you've given us some sort of very practical advice in terms of how to identify the best fact witnesses, and then also how to assist them in understanding what their role is in sort of adducing information that is going to go into an arbitration proceeding. Perhaps now we can pivot to discussing a different type of evidence, and I think one that is perhaps, in some ways unique to these types of, construction or infrastructure disputes, and that is site visits. I think site visits are increasingly common in these arbitrations, and they can provide the tribunal with very helpful insights into what exactly is this project and what went wrong. And site visits are becoming, I think, increasingly scrutinized in terms of something that can be, very helpful, but also very costly. And it's, of course, a very hot topic in arbitration circles, especially among practitioners who deal with construction disputes, as to how can we advance new technologies, including drone usage or AI, to better facilitate site visits. And I think to that end, the International Bar Association just last month published its IBA site visit model protocol for international arbitrations, which I think is intended to assist parties in discussing and organizing their site visits. So it is maximally helpful while reducing costs and time, and also reflects the working group that put these protocols together, their sort of opinion on what are some of the best international universal practices for site visits. So perhaps Simon, Aisha, you can kick us off with a discussion as to what role site visits play in these international construction disputes, and if they've been helpful or if they've presented certain unique challenges that have had to be overcome in these types of arbitration cases.
Aisha, do you want to go first, or?
Yeah, sure. If you don't mind, Simon.
Yeah, no problem. Cheers.
Or on this call, maybe it's gentlemen first. We outnumber. You're.
I like that.
I think maybe it's gentlemen first on this. This.
Fine, Aisha. Feel free.
Go ahead. Kick us off, and I'll follow you.
Okay, so site visits. I've been involved in site visits to projects, but not necessarily ones that have been formally dictated by a tribunal, although I am familiar with that there is an increase in use of that now. It's of particular relevance, I would say, for technical experts, where there's been a failure to a boiler, for example, or a process facility isn't performing to its specifications or standards, etc. In relation to delay and damages, which is more in the line of Laura and I, sometimes it's beneficial for familiarization with the project, particularly if it's a large infrastructure project like a hydroelectric plant or something of that kind. So familiarization with the project is sometimes beneficial. When you're giving evidence or you're writing your report, you can kind of visualize what you're talking about. I can give a particular example where a site visit I did find was extremely beneficial, and that was in relation to a hydroelectric project where there was a required change in the means and methods. There was significant delays to the project and a requirement to accelerate the works. And that meant a change in the means and methods of placement of concrete, and also a change in the means of methods of the erection of the turbines. So in this instance, the requirement was to kind of split the level of the work. So you've got large, basically concrete towers. And there was instances where the mechanical works were now being performed at the same time as some of the concrete works, which in the original schedule and program of the works was completely segregated. So in that instance, on the site visit, you got to see the actual placement of the boilers, of the turbines, where they were being welded in place in smaller segments in an attempt to try and speed up the works. And there's a significant cost increase because of that acceleration. And seeing that actually in progress rather than trying to understand it from drawings, etc., was definitely beneficial in explaining why the acceleration was implemented, and also visualizing and explaining the cost increases because of that acceleration in relation to the likes of productivity, etc. You've got more equipment on site, you've got more labor on site in confined spaces, crossover of different types of work, etc. So seeing it actually in progress was definitely beneficial and made it easier to explain both in the written and oral evidence.
Just to add to what Simon is saying, and I've experienced site visits as president of a tribunal. I've experienced site visits in dispute boards, and I think it is really important. While site visits can be useful, they do add an element of time and cost, and you really need to reflect on and the IBA guidelines highlight this, that there is two possibilities for site visits. One is for collecting evidence, where experts actually go to the site to maybe measure or to test or to sample. And the second is, and that can be an agreement before the arbitral tribunal is constituted, early on in the dispute, and that's between the parties themselves. Or it can be something where you're trying to paint a better picture, like Simon is saying, where you want the arbitral tribunal to see the site, to have a picture paints 1,000 words. And so you want the tribunal to contextually understand the project and therefore be more efficient in actually deciding the dispute. And so the site visit can be a useful endeavor in both instances. And you need to reflect what it is that you're trying to achieve with this site visit, and the state or the phase of the project itself. I mean, if there is an electrical wiring fault and the building has been constructed and closed, and you will not see anything from a site visit, in that case, a site visit is really not useful for the tribunal to gain further understanding, and it would be a wasted cost and efficiency, waste in cost and efficiency. So it's important to have that discussion early, what you're trying to achieve, and when it is that you're going to visit the site. I've been involved in power plant or road construction, where the site visit really helped the tribunal, like Simon has pointed out with a hydropower plant and where you're placing the turbines, and what does it mean to be actually increasing that cost, or transitioning the positioning or the method of construction. And it really brings to life to the tribunal far more than any written pleadings can do. So, but if that is going to take place, it is important, and I would say, I would point out page 28, and this is Article 9 of the IBA guidelines. It is really to understand what the guiding principles for this particular site visits are going to be. Are you taking evidence during the site visit, or are you just pointing out context? So what are the stops? What are you trying to achieve? What do you want the tribunal to understand with that particular stop? And the parties have to agree that. Is there going to be advocacy allowed or not? Are there going to be questions and answers or not? And because while a site visit can be very useful, it can be a dispute within a dispute. And so they need to be structured and they need to be controlled in a very systematic manner. And I think they have a place in arbitration. They don't belong everywhere in arbitration and every construction arbitration. You need to think about them maybe in the first case management conference. And if you're you decide to proceed with a potential site visit, it needs to be meticulously planned and fully agreed by the council. And I think the IBA guideline is very helpful as a starting point to think about those things. And then, if it is within the arbitration, it needs to be issued as a procedural order. Maybe a consent procedural order would be a happy place with having the parties' agreement, but definitely it needs to be strongly controlled. So
Absolutely.
Up there.
And Katie, if I may point out that there's an alternative to site visits, making the best use of technology. One is easier, record a video, and I've used that to complement my testimony in some occasions. But there's also in 2 instances in which there was a site visit that was attended only by the site team and 2 representatives of all parties, and was followed live on Teams by the tribunal and the rest of the lawyers and the experts team, which I found quite cost effective. And there were question and answers live. Was an interesting way of alternative to in-person site visit.
Great. I think those insights are incredibly helpful with Simon's illustration and, of course, the additional guidance provided all by Simon, Aisha, and Laura. I think it seems like our sort of general takeaway is that these site visits can have a place, but you have to have a plan. And in formulating that plan, relying on sort of these universal guidelines like the IBA site visit protocol and considering ways to use technology to facilitate a site visit is going to be especially crucial to the parties and to the tribunal and, of course, to the experts that support them. On that last point, perhaps we can turn to discussing expert evidence, which is perhaps a natural...
Sorry, there is just a question that was in the Q&A, and it deals with the site visits, and I don't know if you want to leave that to the end or you want to take it within the site. Sorry to have interrupted.
No, that is great. And I'm so glad that we have a question from our audience. And so I will read that out loud and I will pose it to whomever wants to answer on the fly. The question writes, are there any repercussions for a party to engage an expert to do sampling on site without informing the opposite party? Can it be argued that one party has had more time to visit the site and do testing than the other party?
I think that's a lawyer's question to answer.
That's fair enough. I mean, I think probably, Aisha, you can discuss this, but it does go to your dispute within a dispute idea of, you want to avoid sort of ancillary accusations or sideshows that distract from the core issues and, unfair advantage and things like due process, of course, typically send chills down arbitrator spines. So something you want to avoid by perhaps disclosing to the other side when you do intend to visit a site, when you do intend to take samples. But Aisha, I don't know if you have anything you'd like to add there.
It depends on who owns the site as well. I mean, the access to the site. I mean, if it's an employer's site and the contractor can't have access to measure and the like, I think it's an arguable situation, but it would be difficult because not all sites are accessible. You might have to have permission and so you can't just undertake sampling as a contractor without the employer's permission. And I would say if the employer does sampling on their own site, I'm not sure that that would be unfair.
Right.
So I think it's contextual and it's very project specific.
Absolutely. And perhaps with that question answered, we'll turn to sort of the final segment of the types of evidence that we wanted to address during this webinar. And that is, of course, expert evidence. And it's probably no surprise, given the composition of our speakers and also some of the issues that we've been discussing so far during this panel, is that technical issues can also often dominate a construction arbitration dispute and require the participation of technical issues, quantum or damages experts, or delay experts, and choosing, I think, the right expert to opine on various issues and to paint a picture for the tribunal that perhaps isn't so easily gleaned from the documents or the witness testimony can be crucial and even outcome dispositive in these types of disputes. So I want to get the perspective of both counsel and our experts here, and discuss a few topics within this rubric of expert evidence in construction arbitrations. But perhaps I will turn things over first to Camila, and perhaps you can provide the perspective as counsel, and explain a little bit in terms of what types of experts you typically look for in these construction disputes, and if there are any characteristics or qualities that you assess in order to identify the right expert for your particular arbitration.
Yeah, Katie, we typically start by identifying the key areas where expert testimony could provide valuable insights or clarification. We need to identify this. And to identify the right expert, we consider several factors. So first, the expertise and the experience. We look for experts who have knowledge and experience in the relevant field, and this includes reviewing their academic background, professional qualification, and previous experience as expert witness. And this is not easy to find. Most of them are very good professionals or professors, but has never played a role as an expert witness in arbitration. It's not easy to find out expert as we have here in our panel. So the second factor is the reputation and credibility. The expert reputation are very crucial. We seek individuals who are well respected in the field and have track records of providing reliable and unbiased testimony. One thing that I like to do here in Brazil in our arbitration is looking for professionals from academic institutions, researchers, for example. In general, their knowledge and their testimony is really appreciated by the tribunal. The third factor is the communication skills. It is important that the expert can effectively communicate complex technical information, and this is very crucial, in a clear and understandable way. This ensures that their testimony is persuasive and easily comprehensible to the arbitrators and to us lawyers. We need to understand the technical issues. And the fourth factor is the independence and impartiality. We prefer experts who can demonstrate independence and impartiality because their testimony should be based on objective analysis rather than any potential bias or conflict of interest. The fifth and the last factor that we should take into consideration is the availability and responsiveness as counsel. So as expert to counsels, the experts' availability to participate in the arbitration process and their responsiveness to our inquiries and requests for information are also important consideration. We need to be able to count on their help for technical matters, because although we lawyers in construction arbitration, we think that we are almost an engineer, in fact, we are not, and we really need their help. So we need to be there side by side and count on their explanation, their clarification on technical points.
Absolutely. And Simon, perhaps I can pass things over to you and just ask, when you get a call from a lawyer like Camila, what is the first thing that goes through your head, or what are the first sort of questions or things that you want to ask to know about the engagement, and to assess, I guess, if it's the right sort of fit for your expertise?
Yeah. Okay. I'm conscious of the time, Katie, as I'm sure you are. So I have a few points that I can raise. There's two stages to this, really. There's before formal engagement and once you're engaged. So before formally engaged, I would want some information about the type of project and a summary of what the issues are. Then for me, the form of contract, I'm familiar with the form of contract, be it FIDIC, NEC, or any of the other standard forms or even bespoke forms that are used by some companies. Discussion on the procurement route, so I can understand, what kind of evidence I'm going to be asking for, etc. And then counsel's understanding, this is important for me, and direction on entitlement. As an expert, you don't want to be getting into arguments on entitlement in your evidence. That's the lawyer's job. Are key individuals for the project available? And then a defined work scope. What am I to give an opinion on? Very conscious of staying in the right lane, for example. The current status of the project. Some disputes and arbitrations are in relation to ongoing projects, and the types of documentation that would be available. And then once engaged, I would be looking for access to the project records, access to individuals on the projects. We've already discussed those points. If it's available, the notice of arbitration or the complaint, any previous assessments that have been done on the issues at hand, be it internal or by outside consultants. And also, if you're in arbitration, the outcome of any previous kind of dispute adjudication hearings, be it dispute boards or expert determination, that can give you some good indication as to the issues that you really need to focus on. Then you would look for meetings with the attorneys and the clients, review of the contemporaneous records, and then Camila, you raised the point quite well. The key is, as an expert, is to maintain your independence. So you don't just want one side of the story; you want both sides of the story. So basically, the universe of documents for the project. So I think I came in just under 2 minutes. So hopefully that.
Well done. And I do know that we are approaching the end of our webinar, but I will perhaps allow us to extend another minute or two over, just given that we started a few minutes after our intended start time. And perhaps we can end with a question posed to both Simon and Laura about what are tools that experts can use when you're in a case that is hotly contested, where perhaps there are multiple different expert voices saying very different things. How can experts cut through that debate and impress upon a tribunal the core issues and convince a tribunal of the merits of your opinions? Have you seen any success in some techniques that are often talked about, like joint expert reports or hot tubbing during a hearing?
Simon, you want to kick off? And
Sure, Laura. So I have seen success and unsuccessful situations with, particularly with joint statements. I think it's important, and this goes back to the other point that Camila raised in relation to independence. The expert's not an advocate and shouldn't act that way. So if both experts are effectively on the same page when preparing joint statements, the key is to narrow the gap. And I think from experience with joint statements, that is beneficial not only to you as the expert witness, but also to counsel as to where the tribunal see issues in the evidence that they've received so far, because the intent of joint statements, etc., is to narrow the gap between the two experts. So in theory, it works well. In practice, most of the time it works well, sometimes not so well, depending on sometimes the attitude of experts involved.
my experience is quite similar. I've had a relatively bad experience with joint expert reports, quite inefficient, and joint expert reports that end up being basically another summary of both expert reports put into beautiful and very well organized cost schedule form. Whereas I do have a quite satisfactory experience with hot tubbing, particularly with hot tubbing that are well managed by the tribunal. And I find that being sitting in person, there's an element of intimidation and that prevents experts from saying some things, or like in this independence Simon was talking about, and also is what could be really helpful for the tribunal if they arrive at the hearing really well prepared with a list of questions or areas to explore, and they can go farther down the road in the hot tubbing at the end of the hearing. Really having two experts responding to very specific questions and handling this conversation in a proper manner, I found that really helpful for the tribunal and quite satisfactory as an expert. I found the exercise both challenging from an intellectual and human perspective, but very rewarding.
Great. I feel like we could probably have a separate webinar series just on hot tubbing and joint expert reports. And but you both have fit in such incredibly helpful guidance to us counsel, and I'm sure to others as well in just a few minutes. To avoid extending even further past our intended termination time, I think we can conclude our webinar with just a huge thank you to our speakers for sharing all of your insights today. It has been especially useful for all of us, and we thank you for sharing your time and for sharing these thoughts and experiences. And thank you to the ICDR and all of our other sponsors for providing us with a platform to have this discussion. Have a great rest of your day. And this webinar has been recorded, so if you want to refer to it in the future, it will be available online. And thank you all very much.
Thank you, everybody.